Okay, good morning and welcome to the 17th meeting in 2013 of the Rural Affairs, Climate Change and Environment Committee. I remind members and the public to turn off mobile phones and Blackberries, etc., because leaving them in flight mode or on silent will affect the broadcasting system. And agenda item 1 today is a decision on taking business in private. This first item is for the committee to decide whether to take item 3 in private. Are we agreed?
Yes.
We're agreed. And now I would welcome Jean Urquhart to the next item, and we expect, I think, also Tavish Scott for agenda item 2, the Crofting Amendment Scotland Bill. And the second item on the agenda is to hear from the Scottish Government's Bill team and then from stakeholders. And I welcome the Bill team to the meeting. Good morning, gentlemen. Richard Frew, Policy Advisor, and Kenneth Detkin, the Senior Principal Legal Officer at the Scottish Government. And I ask Richard if he'd like to give any brief introduction to this session.
Thank you, Convener, members. Thank you for inviting me to give evidence to the committee on the Government's Crofting Amendment Scotland Bill, which was introduced to Parliament on the 9th of May. I'll briefly cover the key points, as I know the committee will probably have questions thereafter. The main purpose of the bill is to allow owner-occupier crofters to apply to the Crofting Commission to decroft their land, like landlords and tenant crofters can already do under the Crofters Scotland Act 1993. The need for the bill to focus on this single issue has already been recognised in Parliament. At the moment, crofting legislation allows an owner-occupier crofter to apply to decroft only when the croft is vacant. However, owner-occupier crofters, like tenant crofters, are required to meet their duty to reside on or within 32 kilometres of the croft, unless, of course, they have consent from the Commission to be absent. This means that the existing provisions in the 1993 Act do not work as intended. The Government has therefore introduced a bill which provides standalone provisions, new sections 24A to 24D, to be inserted into the 1993 Act. This should be simpler and clearer for owner-occupier crofters, their legal advisors and others involved in that process to follow. As well as allowing owner-occupier crofters to apply to decroft the whole or part of their croft, whether the croft is vacant or not, the bill allows the Commission, in considering these applications, equally to give decrofting directions. The bill also allows the Commission not to consider a decrofting application if they have already required the owner-occupier crofter to submit proposals for letting the croft. This will apply when action is being taken by the Commission to address a breach of duty under Section 26J of the 1993 Act and mirrors the current legislation when the Commission requires letting proposals from landlords of vacant crofts. The bill applies Section 25 of the 1993 Act to owner-occupier crofters as it applies to tenant crofters and landlords, but disapplies parts of Section 25 which only relate to tenants. For example, the tenant crofter exercising their right to buy the croft under Section 12(2) of the 93 Act. In this case, the owner-occupier already owns a land. The bill also provides the same right to owner-occupier crofters as that afforded to tenant crofters to decroft the site of the dwelling house on the croft, where they have not already decrofted a house site previously. It also provides that, in the event of a breach of conditions relating to a decrofting direction, the direction is revoked. The sanction in the 1993 Act for tenant crofters is that the croft is declared vacant, but this is inappropriate for owner-occupier crofters, since Section 2310 of the 1993 Act provides that the croft is not vacant if it is occupied by, amongst others, owner-occupier crofters. Section 2 and the schedule to the bill make consequential amendments to the 1993 and 2010 Acts as a result of new sections 24A to 24D. These mainly add cross-references to include the new provisions. Section 3 of the bill enables the new legislation to be applied retrospectively, as if the new provisions had commenced when the definition of owner-occupier crofter was introduced on 1st of October 2011 by the 2010 Act. These provisions are necessary to address concerns that the Commission acted out with its powers and other concerns relating to the subsequent transfer of title to land subject to a decrofting direction. The Bill therefore directly addresses the issues relating to the 159 decrofting directions already issued before the Commission stopped processing these applications. The Bill also provides for the 50 applications held in abeyance by the Commission to be treated as competent applications. This means that they can be processed once the Bill provisions come into force, subject, of course, to Parliament approving the legislation. This ensures that all 209 applications already processed or held in abeyance do not require to be resubmitted, thereby avoiding unnecessary administrative burden and, of course, expense on both the applicant and the Commission. In effect, the retrospective provisions will place individuals in the owner-occupier decrofting process where they expect to be. On 25th February 2013, the Crofting Commission published a note indicating that owner-occupier crofters could no longer apply to decroft their land. During the 42-day appeal period before 25th February, i.e. from 14th January, it is possible that someone relying on the Commission's statement may not have appealed against the decrofting decision or direction in the belief that their appeal, like the application and the decision, may be incompetent. For fairness, therefore, Section 4 of the Bill enables an appeal to be made within 42 days of the legislation coming into force on the 22 applications affected. The Bill also contains transitory provisions to ensure the provisions in the 2010 Act relating to the Crofting Register apply equally to owner-occupier crofters' decrofting applications. This means that registration will remain voluntary until 30th November this year, 1 year after the register commenced, with the requirement to register croftland subject to a regulatory application being effective thereafter. And finally, Sections 6 and 7 of the Bill are self-explanatory, although Section 6 will provide for these provisions to come into force following royal assent, which will allow the legislation to address owner-occupier crofter decrofting applications as early as possible. I'll maybe just mention very, very briefly at this stage, there's two things that the Bill doesn't do. It does not address the definition of owner-occupier crofter in Section 19B of the 1993 Act, nor does it address another issue raised that is multiple owners of distinct parts of the same croft. That's really because that also relates to the definition of owner-occupier crofters rather than the decrofting by owner-occupiers being addressed in this Act. To do this in this, or rather this bill, to do this in the bill would widen the scope of the bill beyond justification for the expedited procedure to be applied to this bill. Hopefully that's a useful overview, and we're happy to take questions.
Thank you very much. In order to set the scene, I wonder if the Bill team have any response to the argument of Brian Inkster, who makes the case that because the current law can be read as saying that owner-occupied crofts could be considered as vacant, decrofting applications from owner-occupiers could still be allowed.
Yes, we've certainly considered Brian's views, and like a number of people involved, it's not surprising that different people reach different conclusions on the issue. It seems clear to us that while that's an issue worth considering, Section 2310 of the Act clearly sets out that a croft is not vacant if an owner-occupier crofter is on the croft.
Could the problem have been solved with subordinate legislation?
Other legal fixes were considered, but we felt that a bill was the most appropriate way for Parliament to give scrutiny and to meet an expedited procedure.
So you did consider subordinate legislation which could have been effected within about 40 days?
Well, I think it was considered, but we considered that a bill was the most appropriate way.
Okay. Thank you for that, for a start. Yes, indeed.
I just wonder if I could follow up on that, because I'd quite like to know the reasoning behind that decision, if it's possible to give it. I'm not sure you said it was believed that a bill would be the most appropriate way, but you haven't actually said why.
I'm conscious that I'm unable to give legal advice that was provided to taking on that point, but it was all other alternatives were fully considered.
Okay.
I think if we can clarify that point further, it might be helpful for the committee to understand our position. Well, Kenny quite rightly says that it's an issue of legal advice. There are no doubt to the committee as well as us that there are provisions in the 2010 Act to, for example, in section 54, that would allow order-making powers to amend crofting legislation. That's in specific purposes. That would not necessarily be appropriate for this particular issue.
Okay, thank you.
It's Graham Day.
Just for the purposes of clarity, the conveners made the point that if subordinate legislation had been used, we would have been looking at about 40 days to fix this problem potentially. What's the time scale, all going well with this bill, for sorting the problem?
Clearly, now that the bill is introduced to Parliament, that is a matter for Parliament, and we will work with Parliament as much as we can to assist that process, and I'm sure the Minister will be equally happy to. Certainly the intention, and as the Minister said on the 28th of March in the Chamber, the intention is to have the legislation through in time for the summer recess.
Okay. Right.
Tavis Scott,
My
we welcomed in his absence.
Yes, my apologies for being late. I went to the wrong room, that's just my incompetence rather than anyone else. I wonder if I could ask two questions, convener. Firstly, would please, Mr. Fu, do correct me if I'm wrong, but my understanding of this as to where we are is that the Crofting Commission's own legal advice found there were faults with the 2010 Act, and therefore that's why this problem occurred. Would that be a fair assessment of the situation?
That's certainly fair, yes.
And therefore, in your discussions with that body, given it's a government-created body, are they now comfortable with the government's proposals to solve this problem?
Yes, I've had ongoing discussions with the Commission. Clearly they're, as an NDPB, they're there to assist with the delivery of government policy. You'll hear later from David Bilharry at the Commission, but I've no reason to believe that there's any difference between what we're doing and what the Commission do.
I take your point about you're not going to share legal advice with parliamentary committees, but have the Commission, let me put it the other way around, have the Commission shared their legal advice with you in respect, again, of their assessment now of the government's proposals to resolve this issue?
Well, the Commission had to make a decision there and then following the legal advice. They put what I personally would say is an adequate notice on their website to state their position on that. I don't think really there was any need to divulge the content of the legal advice, but that would clearly be a matter for the Commission.
Indeed, but sorry, I more meant now. Is your understanding that they've taken legal advice on the government's new proposals to deal with this, and have they shared that? Have you discussed it with them?
Well, it was very, very useful to have a member of the Commission assisting the Bill team. Okay. I'm afraid he can't be here today, but certainly we're working that closely with the Commission to make sure that, quite frankly, this works for everybody involved.
Yeah. All right. And one final question, if I may, convener, and that's on Mr. Fu's final point there about the issue of, in your opening remarks, on the issue of crofts that are vacant and are held, as it were, by joint landlords. I've certainly written to and presented evidence to the Minister on that, and I know other colleagues have from across Parliament. And I think if I got you right, Mr. Fu, you said that couldn't be dealt with in this bill because it would widen the scope of the bill more than was considered to be appropriate. But when is it going to be dealt with? Because I'm sure you well appreciate that it is a very, very significant issue, and what it's really meaning now is that lots of crofters are being told, consult your lawyer, and meanwhile nothing happens.
Clearly the government hasn't given that advice to consult lawyers. That would be a matter for individual crofters themselves, or people who, in this case, aren't necessarily crofters. They're people who hold, in some circumstances, distinct parts of the same croft. They therefore don't fit within the definition of owner-occupier crofter in 19B of the 1993 Act. When we address that and whether we address that is really a matter for the Minister rather than for civil servants to determine if, for example, particular legislation is brought forward at any time.
I appreciate that's a policy issue for ministers, but would it be fair to say that this is a significant issue? Do you recognise that it's now a prevalent issue across the Crofting counties and causing significant challenges to lots of people trying to get about their normal lives?
I wouldn't necessarily say it's significant. The Commission has considered ways in which it could regulate these people in certain circumstances. For example, the submission of a regulatory application. My understanding is that the Commission has advised that those people who are, in effect, owner-occupiers previous to the 2010 Act can jointly apply to the Commission as long as they do it jointly, collectively as landlords.
But they're not, that's the point. They're not agreeing to jointly act in that way. I agree with you. If that was happening, I would entirely agree with you, but they're not. That's the point.
Yeah, I would hope that everybody would be able to work together at some point to recognise the benefits.
We don't live in a perfect world, Mr. Frew, I think.
Well,
thank you for that. I appreciate that. Yeah.
Yeah.
Well, it's an interesting issue which may affect some crofters. We don't know how many, unless Mr. Frew can give us any ballpark figure at the moment to suggest how many.
I'm not aware of the exact figures, but I'm sure the Commission certainly have a list of the different types of crofter.
Yeah. Okay. We move on to the effects of the cessation in improving decrofting applications. Bring in Claudia Beamish.
Good morning to you both. When the Crofting Commission learned of the potential legal problem, it suspended the consideration of 50 decrofting applications from owner-occupier crofters that were before it, as of course you will know. The Crofting Commission has also stopped accepting decrofting applications from owner-occupier crofters, as I understand it. Could I ask you both, as appropriate, to comment on, could I ask you about the 50 decrofting applications which have been suspended and the fact that the Crofting Commission has stopped accepting these, and if the bill were passed before the summer recess, which I understand from evidence today already is a possibility, when might the Commission be able to decide on the decrofting applications that are currently before it, and when would the Commission be able to open the door to new decrofting applications from owner-occupiers? And what practical problems are these delays causing? What help can be given to those affected?
Number of questions there, but
yeah,
I'll try and
one at a time, but to give you a general...
Yeah. Of the 50 applications held in abeyance, the Commission have undertaken initial checks on these applications. If Parliament passes this legislation, there is no reason to delay any processing of these applications at the Commission. Furthermore, additional applications from owner-occupier crofters, likewise, there is nothing to prevent, if the legislation goes through, owner-occupier crofters then submitting their applications in effect in accordance with Section 6 the day after royal assent.
Then, sorry to have given rather a range of questions at once, but the practical problems in terms of the delays, are there practical problems being caused, and what help can be given to assist with these?
Yeah, I think the Minister alluded to a number of the known problems, and it was very, very helpful when this issue arose for representative organisations to provide information on really what's happening on the ground, and so that we could have examples of why quick legislation was necessary. I'm certainly aware of, for example, a young couple being unable to take over an owner-occupier's croft, or the decrofted part of it, to build a house and start up a new family. And there are other similar issues. But general transactions, crofting transactions, clearly could be affected.
Thank you.
Right, okay. Any other parts to that people wish to ask? If not, then moving on to timescales and the solution in the bill. Jim Hume?
Yeah, thank you very much, Convener, and good morning, gentlemen. As you said yourself, Richard, it was the 28th of March that Paul Wheelhouse made a statement, the Minister, that there would be this legislation needed. That's 48 days ago. It's not, we've not had any formal consultation, which is very unusual for any piece of legislation in any legislating government. And they're always concerned that, prepare at haste and regret at leisure comes to mind, and maybe that's part of maybe what happened with the 2010. So I'm concerned that this is getting rushed through, obviously, and we're not having due process. So could you tell me what sort of consulting you've actually done with stakeholders specifically?
Absolutely. Right from the first day this issue arose, we were in consultation, ongoing consultation, as I mentioned earlier, with the Crofting Commission, and certainly with key stakeholders, NFUS, SCF, etc. Clearly, there were a number of concerns expressed. Not only on the issue itself, but how it could be taken forward. We have adopted, the Parliament will adopt an expedited procedure, fast-track procedure. That is allowing the Parliament, I think, a fair time to consider, scrutinise the legislation more than, for example, an emergency bill would. So I think we're in a better position from that perspective. As far as consultation in the Scottish Government is concerned, clearly we face the same timescales as everybody else, but we have tried to consult as widely as possible within the timescale. Only on Friday, I met with a number of key stakeholders to discuss, once the bill was published on the Parliament's website, to discuss the detail of the bill. That was very, very useful in gathering thoughts on the proposed legislation.
Okay, but if I was correct in saying, you did say in earlier that you're not 100% sure how many actual crofts would be affected by this bill. Perhaps would you agree that a full consultation would maybe have eked out those figures where we are at the moment?
I don't necessarily think so, because it's very, very difficult to forecast, for example, how many applications will be submitted in any year, how many people are actually out there. Unless every single person comes forward, we would never reach the exact figure. I think we've done as much as we can to address the problem, irrespective of the number of people involved, and I think it's a suitable way forward for addressing it.
Mm-hmm. Okay, and just to the final part of it, you've said already that you've taken legal advice, obviously, but with the own bill team, the government lawyers, do you think they've had enough time to actually see all the implications of the bill, or do you think we're at a stage where actually more input is needed to them?
I'm certainly happy to invite my legal colleague to answer that.
The bill as proposed has been fully considered by legal, and I was at the meeting on Friday as well, which we both found very helpful to receive views from stakeholders, including a lawyer who was there that I think you're hearing evidence from later.
Dick Lyle.
Yes, on the point that Jim Hume has just made, that this is being rushed, would you agree, Mr Frew, that the 50 applicants want you to rush it because you mentioned that a young couple couldn't build their house, that's holding them back? So would you suggest that the 50 applicants whose applications are waiting to be passed are actually wanting you and the government to rush this?
I think you're absolutely right there. I think the 50 applicants would have submitted decrofting applications for good reason, and that could include some sort of development. But not only the 50 applicants, I think there was general acceptance that by everybody involved that the issue had to be addressed as quickly as possible, not least by Parliament itself. Parliament recognised the need for to address it quickly.
Okay, thank you. Thinking about other aspects round about these crofting matters, we've got some questions, first of all, from Alec Ferguson.
Thank you, Convener. If I could perhaps just comment that I think the concerns that some of us have in relation to this bill is that I suspect that in the 2010 bill, you and other officials were saying exactly what you're saying now, that all the bases had been covered and all the advice had been taken, everybody's come to. And I think that's one of the worries that we have. That's more a comment than anything else. But can I declare my hand as a complete layman in crofting legislation. I come from the extreme southwest of Scotland, and this is a different world to me altogether. But I realise, obviously, that we're in a very complex area for all sorts of reasons. And as has already been mentioned, I think, in Tavish Scott's questioning, that the issue of multi-ownership is one of many other issues that still need to be resolved. And I just wonder whether, this whole area does seem to me, it's a bit like Hydra. You cut off one head and two others appear. You get rid of one problem and two others appear in its place. And I just wonder whether it's possible for you to give an idea of what other issues have been identified during this process, 2010 and now, and what timescale the government might have in mind to addressing them, basically.
I'm certainly aware that there are other issues, albeit not to the scale, with not just the 2010 Act, but the 1993 Act, and of course between that the 2007 Act. But I think it's everybody's responsibility, certainly from the development of the legislation, in this case in the Scottish Government, but also through Parliament, to ensure that legislation is fit for purpose when it's passed, and it delivers what it intends to deliver. I think we need to all work closely to make sure that that's the case in this particular bill, focused as it is. There are examples, and I mentioned one earlier, the definition of owner-occupier crofter in section 19B of the 1993 Act, that I would like to have a look at, as has been mentioned earlier. There are some people who don't necessarily fall within that definition as it is in the legislation. Whether they need to clearly can be considered at that stage. There are other issues in the legislation, but mostly I would think cross-references as an example, the register provisions and how the legislation interacts, different sections interact. So yes, it would be very useful to look at these, but when and how, as I said earlier, is a matter for ministers.
Could I just have a very brief follow-up, Kavita? Thank you. Is it possible to say, what degree of priority needs to be given? How important is it to look at these? Because I'm afraid I genuinely don't understand. How important is it to address these? And if it is important, presumably if it is really important to look at these things, then it ought to be addressed fairly soon.
Well, as I said, when something is addressed is a matter for ministers. Sorry if I sound repetitive, but I think we have to, before taking forward any legislation, we have to carefully consider what that legislation would do, what the issues we're actually addressing, what we're trying to address. And if there is something that is highlighted as a particular problem, then clearly we would want to look at not just legislation, but other ways of resolving it. Administratively, for example, would be the first preference, I would think.
I'll leave it to others more expert than me to follow up that if it's needed.
Okay, Jane Baxter, would you call yourself more expert than Alec Berg?
That's not the moment for me to appear when you're looking for an expert. I'm not the expert in this committee. Morning. I'm wondering if other legislation is needed. What are the other options that would be open to the government when they go to consider resolving these issues? You've mentioned legislation and administrative processes. Can you give me some examples of that, just based on my pure ignorance? That would be very helpful. Thank you.
Sure. Well, there are clearly the obvious ways to bring forward further legislation to amend, further primary legislation to amend the existing legislation. We would have to also look at, as I mentioned earlier, the Section 54 powers in the 2010 Act. Just to see if they could be utilised in any way. They are for very specific purposes, and it would we would have to consider whether, for example, as in this case, that the legislation being brought forward, whether it changes the policy or whether it's deemed to be that the Act needs tidying up or clarification.
I would say as well that provision in section 1.3 for ministers to give directions to the Commission, so that could be another avenue to explore.
when do you think the government might be, I know I'm asking you to second guess what other folk will do, but will they speak to the Scottish Law Commission about this? Will they take advice about how to take this forward or when to take this forward? How does that work?
From a civil servant's perspective, I would first and foremost, as I've said already, I would rely on ministers for guidance on timescales. But we in the Scottish Government clearly have our own legal team and law officers to address legislative issues. On occasion, certainly the Government has, and my involvement in land reform previously, we sought the Law Commission's views on various legislative measures. So certainly that's an option.
Thanks, Convener.
Thank you very much. Looking at the financial memorandum now, Graham Day.
Thank you. Good morning, gentlemen. Mr. Frew, you talked earlier about the initial checks of the 50 applications that have been held in abeyance having been made. But can you explain how this helps explain the financial allowance for considering these applications in financial year 2013-14 being set at £30,000? Because when taking average costs for a decrofting application, we would, in the normal course of events, be looking at a figure of a little more than double that.
That's right, and I see why you may reach that conclusion. The figure of 30,000 in the table towards the end of the financial memorandum reflects the figure in paragraph 10 of £26,433 that the Commission has estimated that it would cost to process the 50 applications. That's on the basis of time spent on the decrofting applications, because the Commission clearly have spent some time already. The 26,433 therefore doesn't reflect 50 times the unit cost, as it were, for that reason.
To be clear, the figure of 30,000 that's set aside for this, you believe covers the cost that will be incurred in this financial year?
I certainly believe that on the basis of the information provided by the Crofting Commission itself, yes.
Thank you.
Okay, Nigel Dunn.
Thank you very much, Convener, and good morning, gentlemen. Can I just pick up on the issue of retrospectivity, if that's a word the official report's going to let me have? Clearly, we don't like making law that's retrospective. We all understand that. There are very obvious reasons why, in this case, we would want to, and I think you've outlined those. I think my concern about what I heard you say was that whilst you had apparently picked up on decisions already made, applications in abeyance and appeals that might or might not arise from decisions already made, there are, it struck me, quite a number of other possible unintended consequences, and I'm just wondering whether you can give me some reassurance that you've thought about, in consequence of those previous decisions, people who've been allowed to buy, people who've not been allowed to buy, mortgages, neighbours, all manner of other ancillary rights which come out from left and right field to bite you. I'm just conscious there are a lot of incidental legal issues, nothing to do with crofting actually, that just relate to land law, and I'm just really looking for some reassurance that you have tried to think your way right the way around the possible consequences of the retrospectivity of what we're doing.
These, you highlight there very appropriately the issues that we have considered. The purpose of the retrospection is to cleanse, in effect, the whole process. That would mean the right from the application being submitted right through to the end result, transfer of title, etc. If at any stage in the process there was a stage that may have still been deemed to be incompetent, clearly that could have a knock-on effect. The result of the retrospection in the legislation means that the whole process is therefore competent. We don't therefore expect any unintended consequences of the legislation.
At the risk of pushing that, can I just remind you of the IO Aberdeen Council case, the policy consequences of assuming that everything was tied up in a timescale, and things turned out not to be dealt with in the timescale, and we finished up in the Court of Session and actually all got our knuckles rapped as a result. Could I just encourage you to reflect on whether you've built in any timescales which the law might subsequently find to be inappropriate?
Certainly, to the best of my human ability, and colleagues, I'm sure as well, we don't consider that there is anything that we haven't considered at this stage. But obviously, we would be interested to consider if any issues do arise.
We understand that civil servants are as human as crofters, so in that light, I think we can thank you very much for that introduction to the issue, recognising the expedited nature of this and the focus that has been brought on this particular problem. So thank you very much, gentlemen, for your evidence. We will suspend briefly in order to change over witnesses. Thank you. All right, we'll recommence and welcome our witnesses for this panel. David Balhari, Head of Regulation at the Crofting Commission, Sir Crispin Agnew QC, Chairman of the Crofting Law Group, Derek Flynn, Chair of the Scottish Crofting Federation, and Sandy Murray, the Crofting Highlands and Islands Chairman of the National Farmers Union of Scotland. Welcome, gentlemen, and intend to start the questions myself. We would be interested to know if any of you have a view about the arguments made by Brian Inkster about the bill not being needed. Derek Flynn, to start off with.
I have brought this matter to the attention of the Crofting Commission, and Brian's response was pretty immediate. I have looked very closely at the existing 1993 Act as amended. It seems to me that Brian has missed one thing, the necessity of an owner-occupier to report to the Commission within 1 month of becoming an owner-occupier is contained in subsection 12. There is a subsection 12A which talks about owner-occupier crofter. Now, owner-occupier crofter is seen to be a subset of owner-occupier. Now, whereas, I'm sorry, this is complicated, and I know most people glaze over when I start talking about it, but owner-occupiers are not entitled to occupy their crofts, and so their crofts can be held to be vacant, and they can be asked to take tenants, whereas owner-occupier crofters are entitled to occupy their crofts. And they have to give intimation to the Commission of that fact, that they are owner-occupier crofters. So instead of them being persons who have to give notice, they are persons who give notice as owner-occupiers, but also give intimation of the fact they are owner-occupier crofters. And I think Brian has missed the fact that these are owner-occupier crofters are a subset of owner-occupiers. It's very complicated, but I've looked at it many, many times since Christmas, and I cannot see how one could be persuaded that an owner-occupier crofter could have a vacant croft. And the two things that are needed for decrofting is an application by a landlord or a landowner, and that it be vacant. And whereas an owner-occupier crofter could be seen to be a landlord under the Act, he certainly couldn't have a vacant croft.
Right, thank you. Do others, Crispin, please?
I've looked at what Brian Inkster has said, and I agree with him that there is an argument to that effect. But it is totally unclear, like many sections of the Act, and we would end up in the Land Court having an argument about it. And I think, therefore, it's a good thing to put this right and beyond doubt. Just to pick up on what Derek Flynn has said, there's a lacuna between section 26J, which says owner-occupier crofters letting procedure, the Commission must, unless they consider there's good reason not to, direct that the owner-occupier crofter submit to them proposals for letting of the croft. So every owner-occupier crofter has to go through this test with the Commission, who have a discretion to decide whether to order him to let or not. That's notwithstanding the rights given by the earlier section to owner-occupier crofters. So that's not another sort of lacuna in the Act. But I think it's a good thing to put this right. My personal view is it could be done very simply by amending section 24(3), which says the Commission, where a croft is vacant, the Commission may decroft. If you said where the croft is vacant or occupied by an owner-occupier crofter, the Commission may. And I personally think that would probably solve the problem. But I haven't looked at it in any detail, having only got the bill on Friday and been in Portree Sheriff Court on Monday and had other commitments. So these are very immediate reactions, and I've taken some soundings from other members of the Crofting Law Group. But it's another complicated set of sections which are standalone, no attempt to really integrate them with the rest of the Act, and problems may come from that. And that's part of the problem of the amendments made in 207 and 210, is that there's no clear link up to all the sections. It's very difficult to achieve that in this particular, in the Crofting context. But that's just my concern, that it's perhaps overcomplicated. But I think in order for it to go through, it's really too late to do anything about that. I've got some specific comments to make on the bill. I don't know if you want me to do them now. And I do have a copy of my notes for speaking to you, if it would be helpful for me to hand in a copy at the end.
That would be very helpful indeed. I think we'll let the members ask questions, and if the points you wish to make have not come out as a result of the questions, then we'll come back to you to discuss those.
There's specific drafting issues in relation to particular subsections, and I think it might be sensible if I had the opportunity to go through those one by one at some stage.
Well, we certainly do that. In terms of the process and the principles involved, we can deal with those and then the detail later. Incidentally, I seem to remember you in 2007 Act having considerable concern about being able to read across between the different acts without the benefit of the time, which you say, Sir Crispin. And we're well aware of that. The difficulties of having a consolidated bill are things which are for another time and certainly won't take an expedited process.
I wasn't meaning that. The Crofting Commission have put on their website a very good make-up of the bill, but it's just from a legal point of view, the sections don't fit into each other and read together, which means that one then has to try to interpret what a section means, because if it means one thing, it conflicts with what's said in the other section, and the land court's always having this problem. That's what I meant, rather than the physical difficulty of actually working out what bit sticks in where, because the Commission had done a very helpful print-up, and lawyers can get it on Westlaw, but the general public can now get it from the Crofting Commission.
Well, thank you for that clarification. I'm slightly clearer for me. You don't have to have an opinion on this, but if either of the other panellists wish to say something just now, you're welcome. David Balhari.
Just one small point to clarify in terms of Sir Crispin was offering an alternative solution. But I guess one of the things that from the Commission's perspective, and one of the things certainly that the board was very keen to see happening, was the retrospective provisions so that no hardship was caused. And the new bill provides for that, so that's welcome.
That's very good.
I wasn't suggesting that there shouldn't be the retrospective parts, but the sort of principal part, I think, could be done more simply.
Okay. Questions from Tavish Scott and from Dick Lyle, but Tavish Scott first.
Thank you, Convener. Can I just, for the record, Sir Crispin and to Mr Flynn, confirm that you believe this bill will actually solve the problem that we want addressed?
Broadly, yes.
Do you want to just quantify the broadly there, please?
Well, as I say, I've got one or two specific comments and criticisms of the drafting, but the broad principle of the bill, I think, should solve the problem, looking at it in the time frame I've had available to look at it. But as I say, I think there are one or two specific drafting things which might give rise to problems.
Mr Flynn, do you have a...
It appears to me that it does solve...
It appears to be.
Yes.
If I may say so, that's very legalese.
Well, I think one has to be with crofting law. It's so complicated.
Okay.
But it solves the problem that was raised.
Quite. Yes. I think that's a very fair observation, if I may say so. And could I therefore ask Convener, Mr Bahari, I was asking the government officials earlier on about the legal position in respect of the Commission's own position. Has the Commission had a chance now to take its own legal advice, again, in this context, on whether they believe this bill now will fix the problem that we all want to see resolved?
So where we're at the moment is that we've, I think it was mentioned earlier, we seconded one of our legal team to help with the preparation of the bill. We believe, as has been said, that this addresses and solves the problem that has been raised. We haven't seen a need to take legal advice on the fix.
That's very helpful. And can I just ask on Sir Crispin's earlier point about the test for the Commission of whom is owner-occupier croft and whom is not. Could Mr Bahari describe to the committee how that works in practice, or is that, as it were, an actual test? Do they have to confirm in documentation, or how will that work in practice to keep that process, as it were, simple and straightforward?
Could you ask that question again, please?
Surely. So Crispin earlier on said that the Commission applied a test to decide who was an owner-occupier crofter. I'm just trying to understand. So did I not understand that correctly?
I think you misunderstood me in that I was referring to the section which says where an owner-occupier crofter reports to the Commission have to decide whether or not they should order him to relet. And that isn't linked in with the, I think it's section 19J, which defines owner-occupier and really gives them a right to be an owner-occupier crofter. But nevertheless, they have to pass through the Commission making a decision on whether to allow them to remain an owner-occupier crofter or look for decrofting. And that's two sections which, again, haven't been sort of linked, because it seems to me they should say, you know, if you're fulfilling your duties, then you're entitled to occupy, but if you're not, the Commission can then look at whether you should relet.
Well, that's clear to me. Just in the context of some of the questions that my colleagues were asking across the committee about if there are unintended consequences we haven't considered yet in this new proposal, has the Commission given any thought to the point that Sir Crispin's made in respect of that area?
With this.
I think that was referred to earlier in the sense that what this bill is designed to do is to address a specific problem. That's not to say that there are other areas of crofting law where there are remaining complexities, particularly round about the issue where people have bought parts of their croft.
Yes. Those are not being dealt with here. So, again, as I was asking earlier on, does the Commission have a view as to how we are going to address those issues, if indeed it believes there are issues there?
It doesn't have a view at this time, other than an awareness that potentially there's a problem there, but it's not in the same league as the problem that came to us with owner-occupiers being unable to decroft. So it was mentioned earlier that there's a policy fix where collectively they can be regarded as the landlord. And what you flagged up quite rightly is, yes, but what happens in a situation of where the respective owners of parts of the croft are unable to get agreement? And that's still to play because the policy is relatively new and those problems haven't come to the Commission yet.
Okay, and just finally, Convener, if I may, given that there's a speed of pace behind getting this legislation through, which I personally agree with because I think this problem does need to be resolved as quickly as possible, is the Commission now in a position to be able to move the applications forward once, absolutely on the day, as it were, that Parliament endorses this legislation? Or not?
Absolutely. So when the bill becomes law, then we can start processing the applications immediately with no further delay.
It'd be fair to say you process them up till the absolute final point of determination.
There are a number of applications that we've got that were suspended at various stages, so we'll just start the process again, just depending on what stage they're at.
Thank you very much.
Dick Lyle.
Vina, gentlemen, I'm not a lawyer, I'm not a crofter, but I note that 1993, 2007, 2010, 2013, we've had to try and deal with this problem. I'm sure it's a very important situation for many people who are crofters, but with the greatest respect to Sir Crispin, Agnew, if you put 20 lawyers, would you agree if you put 20 lawyers in a room, you'll come up with 20 different answers? How, in regards to the interpretation of the law, do you believe, and I take the point, I think the point was made earlier, that the difference between an owner-occupier and an owner-occupier crofter can be a world of difference on whether they can fit into this Act or not. So, again, what was asked earlier, Mr. Brian Inkster said that we can deal with this problem elsewhere. Sir Crispin earlier has come in with the factor that he has other items he wants to present to the committee. Can you really say to me that what we're going to do in this bill is going to solve this problem, but can you also agree with me that there will be other problems which need to be addressed but may have to be addressed at a later date because people haven't even thought of them yet?
You can, when you have two lawyers, one can give different opinions. If something is well drafted, then generally speaking, one ends up with lawyers giving the same advice, but not always. But some of these problems have arisen. Another one was drawn to my attention while asking round, and that is that the definition of owner-occupier-crofter means that if there's a development, wind farm or otherwise, and the owner-occupier-crofter reaches an agreement with the developer, that's not binding if that croft is then subsequently let as a croft. Under Section 5.3 of the Act, if a developer reaches an agreement with a crofter to allow the development to go ahead, you can get the authority of the land court, and that is then binding on singular successors. But if you get the agreement with the owner-occupier, crofter, there's no way of making that agreement binding on the croft for the future. And I've been told by one firm in Edinburgh that this is holding up a number of wind farm developments in the north of Scotland because the developers are going shy because those particular crofting townships have quite a number of owner-occupier crofters. There are a whole host of issues that have arisen from the definition of owner-occupier crofter which are causing problems. There are other problems, but that particular, if one's dealing with just owner-occupier crofters, for example, if a crofter buys 99% of his croft, he remains the tenant of 1% and is a crofter of that 1%, but is not an owner-occupier crofter of the 99% and subject to the duties of an owner-occupier crofter. He is just an owner-occupier of a vacant 99%, which he can be ordered to relet. We're then back to the discretion of the Commission, which is what applied from 1976 onwards, where they said you're a vacant croft with the owner-occupier and occupation, we won't do anything about it, provided you behave like a crofter. And the whole purpose of the definition of owner-occupier crofters was in a way to take away that discretion and bring the owner-occupiers under the Act, but it hasn't achieved that. Now, those are all separate from this particular problem that has come up, but this particular problem has come up because of the bad definition of owner-occupier crofter, which has all sorts of other implications beyond just this particular problem. And in a way, this is a missed opportunity for not putting right all those other issues as well. And, wind farm developments are being held up. The government policy is to have 100% renewables by whenever, and yet a faulty definition is impacting there, but nobody seems to have any urgency to put right all these other problems.
Mr. Flynn,
but if we are just...
I'm watching you, Mr. Flynn. I'd be very interested in your answer to the points I've made and also Sir Crispin Agnew's made.
Thank you. The problem of owner-occupier crofters have been here since 1976, since crofters were given the right to purchase their crofts. It was with me throughout my legal career. I'm now retired. I'm now writing about crofting law. I am a harmless drudge. I am concerned about accessibility to law because it's really the crofters out there that want to know what the law says. The Federation goes out and talks to crofters. We've been out talking about the new crofting register, which is a great mystery to all crofters. and how they must map their crofts. But these are things, practical aspects of crofting law. So far as getting 20 lawyers, well, I don't think you'd find 20 crofting lawyers prepared to sit and talk knowledgeably about crofting. There may well be, as we know, more than 20 lawyers wanting to listen. But even the very first extra problem that Crispin raised about Section 26J, I disagree with him on that. And so, disagreeing with Brian Inkster and disagreeing with Crispin Agnew is part and parcel of what is a very complicated piece of law. In a textbook over a century ago, it was said that crofting law was more complicated than the tax laws. And every time there is a reform, it is always stated that crofting law is going to be simplified. And every time we get another layer on top of what has gone before. And in the 2010 Act, we've got the Crofting Register placed into the Act. But it's all done in such a way that it's virtually impossible for lawyers to understand what the law is, let alone the layman to understand, to go and find it. That was the case. In 1990, I was involved in writing a book with D.J. McCoush, who was the retired solicitor to the Crofters Commission. And we heard that there was going to be a consolidation. At that time, the Land Court would stop a case at the beginning and say, can we sort out just what the sections are we're arguing about here? Because we had the 1955 Act, the 1961 Act, the Law Reform Miscellaneous Provisions Act was 68, we had the 1976 Act. And it took a long time for us to figure out just what the wording was that we were going to be using in that particular case. Now, in 1993, we had a consolidation. We put everything in one place so we could find it. But it didn't attempt to sort out the problem of owner-occupier crofters, of which by then we had quite a few, because they'd been buying their crofts since 1976. So it was never sorted out in 1993. And we just got another layer of law in 2007 and 2010, and we haven't really sat down and had it sorted out how it's supposed to work. It goes back and forward, and it's very difficult to understand what the law is. There are very few specialist practitioners. There is a crofting law group, of which Crispin is the chair. I believe the Crofting Law Group has a part to play, but there is a problem of identifying all the things that are causing a difficulty in getting them in the one place. Is the new Crofting Commission to collect all these problems so that when we do come to consolidation, we can talk about pre-consolidation aspects and identify just where the problems are. The Scottish Law Commission have said that they won't be looking at crofting law. They've told the cross-party group in crofting that they will not be looking at crofting law. So somebody's got to do it. And we just don't want another layer on top.
Thank you very much. It's useful to have a seminar as well as answering questions, but it gives people a context which I think is very important, so thank you for that. Graham Day is a supplementary.
A brief supplementary. I mean, clearly we're here to talk about this particular bill, but just in passing, given some of the comments that you've made, Mr. Flynn, and the remarks you made about disagreeing with Sir Crispin and disagreeing with Mr. Inkster on aspects of this, how on earth could we get to the point where we simplified this? Is it a case that we need consolidated legislation, or would you start with a blank sheet of paper and try to do it that way? Yeah.
Could I answer that question? My personal view is that it is unfortunate that crofters are in a special position in the crofting counties. It seems to me that if there is a social need for a crofting type legislation, it should apply to everybody in those crofting areas. We have the unfortunate situation that in 1886, certain holdings were defined as crofts and certain holdings were not, where they are precisely the same. You have lots of small farms in the crofting counties which are really no bigger, no different from crofts. and yet they're under a totally different regime. And this is my own personal view, that if you have to have a social policy for an area, that social policy should apply to everybody and not to a privileged few. Albeit some people say the greatest blight on development in the crofting areas is the Crofting Acts. So I would recommend starting with a blank sheet of paper and decide what your social policy is for the area in respect of small holdings and then apply it. But that's not what we're here for. I'd like to just go through some of the particular problems I see in the drafting of this bill.
We'll get to that. Alec Ferguson wanted a point on this just now.
Well, it's really because I think this has rather encroached onto the area of questioning I was hoping to have later on, Convener, if I could just really sort of bring the point in I wanted to do at this point. Derek Flynn, I think, said that when in answering a question that this bill, I think I wrote it down, will solve the problem that has been raised. And I come back to the Hydra situation, that you solve one problem and create two more. Can I ask whether you believe this bill specifically is going to bring any other problems to light? And can I also ask, just in the, I mean, it's clear to me that if we could somehow simplify this to, or even do away with crofting law, you wouldn't actually need 20 lawyers in a room. 5 would probably do. This seems to me to be an area that breeds lawyers, I suspect. Not that I'm saying that's a bad thing necessarily. But I think what I really want to ask is, given, I mean, there's obviously a need to simplify this, there's obviously a need to consolidate all of this wealth of legislation. Given the complexity that you've all referred to, and the tightness of parliamentary timescales, is consolidation actually possible? I'll just drop that into the seminar.
The Crofting Commission have consolidated the bill in that they've typed it all up in the appropriate places, so one's got access to it in that way. But, you know, for example, the legislation has not repealed certain sections, but appears to have moved them to other parts of the Act. So I think legally we still have those sections live because they haven't been repealed, and we have those sections repeated somewhere else, sometimes for slightly different wording. So there are sort of problems like that. We're working around it in that Westlaw says these sections have not been repealed, but they've been moved. And so when you look at the Westlaw print, you've got sort of pages of blank saying not repealed but moved, and then you look and you find them somewhere else. Yes, they could be consolidated if you're going to consolidate without doing any amendment. But the reason we lawyers are all in dispute is the sections are not clear. You know, when they're not clear, there are two opinions. If the section was clear, then there would hopefully be only one opinion. But, you know, legislation, because it's dealing with broad principles, usually never ends up as clear as it might be. But the crofting legislation is more obscure than a lot of other ones. And part of that obscurity comes from the layers that have been put on it over the years without really thinking it all through. But I think, just to go back, I think this bill solves the particular problem by making it clear that the Crofting Commission can decroft owner-occupier crofters. Brian Inkster may well be right. Derek Flynn may well be right that he's wrong. But until one's gone to the land court and the land court made a determination, it's sensible to clarify this and say, for the avoidance of doubt.
Back to my original question, are you happy that it's not going to give rise to 3 other problems that don't currently exist, Mr. Flynn?
Well, I would like to respond. I do think the bill covers the point. And that was the question that was raised. What is the authority of the Commission to decroft on the application of owner-occupier crofters when it's said on the website they could do so, and it didn't seem to be any power in the Act. So that answers that question. As for the future of crofting, to repeat Mr. McCushy's phrase, I may not live to see, but there has recently been, and I've spent the last 12 years of my legal career involved in committees looking at reform of crofting law. And I do think the investment of the new crofting register gives us a system that begins to be useful. I have to go talk to crofters, and I have to take the view that what is the law is what we're working with. And it seems to me it is hardly the sign of a mature system that we cannot identify the land that we occupy. And it's a very strange thing within Scots law that the contract of landlord and tenant does not force the landlord to explain what he's receiving rent for. And the onus has been put on the tenant to identify what he's paying rent for, and the costs associated with setting up the register on behalf of the applicant are being paid by the crofters. Now, there are things about that which I can raise, like even putting no newspaper advertisement. If every crofter who has a croft, and there are 18,000 of them, has to pay £100 to explain that he's got his croft in the register, crofting is paying £1.8 million to advertise the fact that they're getting their crofts in a register. For what purpose? So there are lots of things in the recent legislation which, and I think the way we're looking at it, we want to see what works, what doesn't work before we consolidate. But I do think there should be some area, some sump that we can put our problems so that when we come to consolidate, we'll have them all together. But I'm not sure who's doing that just now. And the Crossing Law Group consists of Crispin, Brian, and people like myself. And we don't disagree on everything. We don't agree on everything. So that's not, I think, the proper place for the sump.
We will, of course, be able to question the Minister about this in due course, and these are general points which are of considerable interest to us, especially if they entail a lot of work during this session. But we must get back to this particular bill, and Graham Day has the next question.
Thank you. In the experience of you gentlemen, what problems is the delay in approving applications causing on the ground? And assuming that the bill becomes law, is there anything more in a practical sense that could be being done now to assist applicants to be ready to hit the ground running, as it were?
I'm chairman of the board of the Scottish Crofting Federation. We have not had a lot of members raising problems because we are giving them the information that something is being done. And I think as soon as that something is done, they should know about it. But as for specific problems, I have none to bring to you.
Anyone else?
I think I would say the same from the NFU's perspective, that the members that are coming forward and asking us the questions of is there anything happening are quite happy that there is something happening. The ones that are there in limbo that have submitted applications, they've got problems and they're waiting. I know several cases where people might have actually sold their house if they had had it decrofted by now, or in fact sold the whole croft because the decrofting of the house was integral to the actual raising of a mortgage for the sale of the whole croft.
Yeah, that's the kind of thing I'm getting at. I mean, what is the scale of the problem out there for the 50 people whose applications are in abeyance? Are there difficulties they're encountering, or are we comfortable that we're going to get this resolved fairly quickly and everything will be fine?
It's not just the 50 people in abeyance, but how many people have not made an application because of this? And I don't think anybody will know until the bill is passed and then any other ones come in.
And how many are holding decrofting directions that are faulty because there was no legal authority for them to be granted. But that's just the nature of the problem, and we're looking for a quick solution.
But, excuse me, the point I'm making is that those who are in abeyance are people who took a course of action, anticipated that would be cleared fairly quickly. So, with respect, surely they are the principal concern here, because they may be the ones who are encountering difficulties.
I think the world in which they live requires things like planning permission before developments can take place. Delays are normal, and I think this is a hiccup this is a lesser delay.
Okay, thank you.
Okay. Jane Baxter.
Morning. I appreciate what's been said about the need to move quickly and minimise the disadvantage that's been caused by this delay. And I know we've talked a lot about legislation this morning, but I just need to be reassured that a bill is the best means of resolving this present problem, and I'd like to hear if any of the panel have got a view about that.
I certainly think a bill is needed. As I've said, I think it could be done more simply, but I think as we've got to this stage, there's no point in trying to say do it more simply. That will just cause delay.
Yeah.
You know, this is how the government have decided to go. By all means, you know, go this way. In fact, I think it could have been done more simply. I don't think it could have been done by statutory instrument, because this seems to be a fairly fundamental change rather than just a correction. But you know, that I haven't looked at that in any great detail. But to say no, you can't go by this way, go by another, will just cause a delay. So I think it would be best that we just proceed with this.
It's helpful. Anybody else? No. Okay. Thank you.
Very much. Jim Hume.
Yes, thank you very much, Convener. It's similar lines of questioning to the Government Bill team, and maybe in particular to Sandy Murray and David Balhari, because their organisations were mentioned regarding consulting. We've got a tight time scale. It was just 48 days ago since the Minister said he was going to move this forward. Obviously, that's a limited consultation. It's not an open consultation. I'd be interested, in particular from Sandy and David and others, of course, if that is a concern to themselves and their organisations.
No, I think we've had ample opportunity. We've been invited to several stakeholders' meetings, as they call them, and although I haven't been present at them all, there's been representation from the NFU, from the head office, and we've had feedback from our members, that especially the ones that are encountering the problems, the ones that had applications submitted or had thinking of putting applications in, and I think that the consultation that was there and then the setting up of the draft is fine, and as far as we're concerned.
Mm-hmm. Good.
From the Commission's point of view, I think the restricted consultation works because there's a very defined problem. And as long as the bill deals with that very defined problem, then the Commission's content. I think if it started to spread more wide, then, as we've heard, it begins to open up many other issues, which probably would require longer consultation.
No, that's good. Yeah, that's
excellent. Angus MacDonald had a point.
Yes, thank you, Convener. Good morning, panel. It's clear from answers to Tavish Scott's earlier questions that panel members generally consider that the measures in the bill provide a watertight solution to the problem of a lack of a legal basis for owner-occupier crofters to decroft land, and we won't all end up in the land court, as Sir Crispin Agnew put it. Given that that's been well covered this morning, can I perhaps move on to cover speculative development of croft land, Convener? I know that panel members are unable to comment on live applications. However, members may be aware of a current situation in North Ballachulish where there's an application to decroft land which has been granted planning permission for 10 houses. And as I understand it, the 2010 Crofting Act gave the Crofting Commission more powers to reject decrofting applications in order to tackle speculation on the development value of croft land. So in that regard, is the Crofting Act as it stands fit for purpose when it comes to preventing speculation on the development of croft land through decrofting?
Well, if I could answer that in relation to this particular bill, and it's one problem that I raised with the Scottish Government team. If you have it available, section 24, capital C, 2, and it's the B Roman 2, which gives owner-occupiers, crofters, the right to decroft the croft house site, and a crofter can decroft the croft house site. But what they've provided is that the application is made in respect of part of a croft which consists of the site of the dwelling house, on or pertaining to the croft, that's all right. And two, they have not previously given a direction under the section to the applicant in relation to such a site. Now, the crofter, the owner-occupier crofter, decrofts the house site, transfers the rest of the croft to his wife. She wasn't the previous applicant, so she builds another house, and then she applies as the applicant to decroft the new croft house site, which she is statutorily entitled to do. She then transfers the rest of the croft to her son, who builds a new croft house. He was never the applicant, so he makes an application and he has a statutory right. And I think that's a flaw in this Act, which is going to, if somebody exploits it, subject to getting planning permission and all the rest of it, has an absolute right to decroft. And it doesn't appear in the rest of the legislation for an ordinary crofter and so on, or an owner-occupier who's not a crofter, but it is a particular provision which I think will lead to precisely what you've raised. That was one of the specific points I was going to bring up.
We'll come back to that, for sure. Yes.
Okay.
Anyone else?
Derek
Yes, Derek Flynn.
That particular point is strange because it seems to raise an inconsistency that as long as that particular owner-occupier crofter hasn't decrofted a house before, he will have the right to decroft a house site. And it does seem that the next person becomes an owner-occupier crofter who would then have the right to decroft. So that is a real problem which I would make a written comment on the bill about. Some of these points that I would make are really not for this forum. I think I would make a written comment within the time scale, which is by Friday. And we don't have much time to make these written comments.
Thank you very much.
Okay, yeah, that would be appreciated, but I think it's certainly something we can raise with the Minister next week.
Sure. Okay, Nigel Don. Convener. Good morning, gentlemen. You will have heard, I think, my previous comment to the previous panel about the retrospective nature of the provisions. Can I just ask you whether you have any concerns about any, I mean, we understand why we're doing it. Do you have any concerns about the way it's being done or any possible unintended consequences, please?
So all I'd just say in response to that is just to reiterate that the Commission were pleased to see provisions in the bill for the retrospective part applying, and also recognise that as part of the bill, mechanisms have been put in place to allow appeals, so that for those that are in this period of suspension that fall within the appeal period, the proposed legislation allows them still the opportunity to appeal, so they haven't been disadvantaged, and that would have been our only concern, but it's provided for. So
I would agree with that. I think that those that have been granted decrofting applications, it would be terrible if they found out that there was some flaw in the law that they could be challenged at a later date.
Okay.
Yeah.
Chris Bennett.
Apart from saying that comfort was required, what lawyers call the letter of comfort might have been helpful, but in fact this hearing today is comfort that things are happening to correct them. I don't have any concerns about retrospectively making existing decrofting directions real.
It's a part that I haven't really had an opportunity to consider fully in detail. I can possibly see if any of the decrofting applications were opposed and they're now being retrospectively corrected, that the person who opposed it might have a human rights argument that it's affecting their rights because if there wasn't a retrospective effect, they'd have another opportunity to oppose the next application. But otherwise, I can't really see much in it. And I don't know how many were opposed, if any.
I couldn't say.
Do we have any indication of that, David?
I don't have those figures with me, but I mean, if those figures were required by the committee, I could get them sent through.
If you could do, that would be a help, certainly. I think we come to the point now where some of the other technicalities that Sir Crispin Agnew suggested might be discussed at this stage in case members have a question, because that's the germane part of making law and our concern to make it accurate.
Well, if I'm going to comment, if the committee could have the bill open in front of them, it might help. My first comment is in relation to the new section 24, capital A, subsection 2. Where it says, in this section, etc., a decrofting direction is a direction that the owner-occupier's croft is to cease to be a croft. Well, it's sensible to define it for this, but we've always called a direction given under section 24 a decrofting direction colloquially. So it seems unfortunate to have a statutory definition that only applies here but doesn't apply to directions given under section 24. And it seems it might be better to amend section 24 to say in 24 and in these other ones, a decrofting direction is a direction. That's just a sort of technical point. 24B, subsection 2, this really relates to appeals. But it says, but the Commission need not consider the application. Now, if the Commission says, well, we're not going to consider the application, that does not appear to me to be any decision, determination, or direction which gives a right of appeal under section 52A. So we don't need to consider, so we're not considering. Doesn't appear to me to be a decision on the application which gives a right to appeal. And therefore, you'll be forced to have a judicial review as your only way of challenging the Commission's decision not to consider. A slightly grey area, and one can argue it both ways, but I think that would read better if subsection 2 was the Commission may refuse the application if, and that gives them one of the grounds on which they can refuse. You then have a decision which is appealable. And it's just to avoid that particular potential argument. I know that those words were in fact used in section 24(3) capital A, which I think came from the 2010 Act, but it might have been the 2007 Act. So it has been used once before, which is why I know it's being used now. But it is, I think it might lead to an argument that you can't appeal to the Land Court, you've got to go by judicial review. But it's effectively a refusal for the reason set out there.
If you've finished that point.
Yes.
Derek Flynn wishes to make.
Yes, just my response is this, that what it seems to do, and it does this in the 1993 Act, it says that the Commission can put the application aside or it can investigate the application, but it's already given a direction. If you look at 24B2A, if they've given the owner-occupier a direction. Now, it seems to me that what it says is this allows the Commission to put an application on the shelf until the other direction is dealt with, and the other direction is appealable. So there is a possibility of that matter being resolved by application to the Land Court. The other matter, I think, and that's to go back to Crispin's first point, I was going to wait until he finished, but to talk about the decrofting direction. If I can just explain, when DJ McCush and I were looking at crofting law in 1990, there was no mention of decrofting. Decrofting wasn't a word that was used in the Act at all. And it was used in the 1993 Act, but we used it in the book because that's what everybody called a direction that took land out of crofting, a decrofting direction. At that time, it was made by the, prior to 76, it had been made by the Secretary of State for Scotland. And it was given to a landlord because crofting tenants had no interest in having land removed from crofting. And that's the whole nub of this problem, that it is, in fact, a problem from 1976 taken when a crofter bought his own croft, he suddenly became the landlord of a vacant croft. So you had the two things you needed, landlordship and vacancy. So the word decrofting is fairly fresh, but decrofting direction certainly it should be unified. Every direction that brings land out of crofting is a decrofting direction, and in the bill it suggests that a decrofting direction is a direction the owner occupies croft is to cease to be a croft. Well, it's every person's. If you can get a decrofting direction, that land ceases to be a croft. Thank you.
Sir Crispin.
Well, I was just going to say, I accept you can appeal the direction to submit proposals to relet, but the Commission is being given a discretion above that. They can consider it, but they need not. And they can say, right, we'll consider an application to decroft the house, but we'll leave the direction in relation to the land in place. So in a way, that's making a decision which would be subject to judicial review if it was unreasonable or so on. But the use of the word need not consider doesn't appear to me to give rise to what's defined as in section 52 capital A as any decision, determination or direction. It is vague, and it may be that the Land Court will say, yes, it is a decision which we can deal with, but it would just be clearer if it could be said they have the discretion to refuse the application if they've given the discretion, and then it's quite clear that it could go to appeal. The next problem is in 24B subsection 3. It's perhaps more in the wording than in the practical application. But what it requires is you apply to the Crofting Commission to decroft. You are then required to apply to register the whole croft, including the area you're seeking to decroft. You then get the decrofting direction, which means you've got to amend your application for registration. Or alternatively, the application for registration has to go through to register the whole croft, and then you have to make a subsequent application to register the decrofted part. The decrofted part continues to be shown on the register for 20 years, because within 20 years it can be called back into crofting. But it just seems to me a bit cumbersome, that, and I think somebody needs to look at the technicalities of it to simplify it, because otherwise the crofter's got to apply to decroft, he then has to apply to register the whole croft, he then gets the decrofting direction, and he's then got to make an application either to amend the original one or a new one to register the decrofted part. And I just think that needs tidying up. My next point is in relation to the interrelationship between 24 capital C and 24D. 24C says that section 25 applies to decrofting directions. That's fair enough. But 24D says where a decrofting direction is given in relation to a croft, this act ceases to apply to the croft. So if the Act has ceased to apply, how can Section 25 continue to apply under Section 24C? And it just seems, I can see how one might argue it would work. It seems to me that the two would be much better run together if 24 capital C said something along the lines where a decrofting these are in my notes, which I'll hand in, where a decrofting direction is given in relation to a croft, this Act ceases to apply to the croft, except as provided hereafter. Subsection 2 then takes in 24C, and subsection 3 or whatever takes in 24 capital D, 2 and 3. That just seems to me a tidier way of doing it. I've mentioned the point about 24C2, the applicant point. My next point relates to subsection 24 capital D subsection 3B. This is where there's an application to decroft part of a croft that's already on the register. And it says the direction takes effect on the date of registration, which means you can apply to decroft. You then have to send an application to the register to amend the register. I think there's a 6-month appeal provisions.
9 months.
9 months, sorry. Appeal provision thereafter. If somebody challenges it, it goes to the court, etc. So the decrofting direction doesn't in fact take effect until the date of registration. But, and that may be quite a long time, when the crofter or crofting owner-occupier is in limbo. But that doesn't seem to appear in 24B subsection 3, which I've highlighted the problems there, which seems to suggest that if there hasn't been a first registration, the decrofting direction takes effect immediately and is subsequently registered somehow. So there's a lacuna, not a lacuna, but a difference of approach between those two. And those really are my only minor points that I've sort of picked up on the sort of drafting issues which the committee may wish to consider. Perhaps I should have put them in as written submissions by Friday, but...
Well, you've been busy, and it's very helpful to us to know that the government can have sight of these, hopefully, as well as the committee, and that...
A copy of this to Richard Frew.
Excellent.
And I did discuss a number of them at the stakeholders meeting on Friday.
Because of the expedited nature of the bill, it was possible to have this set of information from you at this time, which is very helpful, because we're conscious that at stage 2 we have a very limited amount of time to deal with this, and therefore whatever comes out of the government's response to this, we'll be able to ask Richard Lochhead or Paul Wheelhouse, whoever comes to see us next week, and get them to respond. So thank you very much for those detailed thoughts. I'm not going to ask about other means of solving these problems now. I think we've gone over much of that at the moment, and indeed we've taken time to get into the detail of this bill in a fashion which I hadn't expected at the outset. But that's helpful because we know some of the problems there have been in terms of the interpretations related to previous bills. So your evidence has been most useful indeed, all of you, at a practical level and also in terms of the interpretation of the law. So I'd like to thank the witnesses for their evidence, recognise that we will be hearing exciting changes perhaps to the government's approach to this next week, and that we would end this particular session just now, and the meeting will move into private. So thank you very much. Good morning.